Thank you all very much, and Mark, thank you for those very kind words. What Mark failed to tell you is that I lost the case 4 times in the Massachusetts federal courts before Mark rescued me at the Supreme Court. So this is truly, the McCullen case truly was a team effort, and I could not have won without Mark's input. It is true that I did a lot of the legwork because Mark was working full-time either at WilmerHale or he was working full-time as a law professor down at Catholic University. The fact of the matter is Mark simply couldn't spare the time to be able to come up here. So I actually used his direction in my preparation of the case. So Mark is being very modest, attributing a lot of the legwork to me when in fact Mark is the true architect of the case. I'd like to thank Bob Joyce and Tom, Andrew, and Phil, and the rest of you for this award. I especially like to thank all of you for coming out here and supporting the Pro-Life Legal Defense Fund. The fact of the matter is, as Mark pointed out, we filed suit in this case, in the McCullen case, in 2008, in January. And we didn't finally prevail until June of 2014. That was a full 7 years. And without the financial support of organizations like PLLDF, it would have been impossible to continue that case. So, what I would like to do tonight is talk a little bit about legal history. A wise man once said that we cannot know where we're going until we know where we've been. So I'm going to take all of you on a trip down memory lane. I think all of you would agree that the United States is in a lot of trouble. I think we're at the point of both moral and financial bankruptcy. The question is, how did we get here? So I'm going to go back to the beginning of our nation. Aside from Native Americans, in the beginning our forefathers came to America in large part to avoid religious persecution in 17th century Europe. The New England colonies, New Jersey, Pennsylvania, and Maryland were conceived and established as plantations of religion that sought to avoid the forced religious uniformity that was occurring in Europe, especially England. Our first immigrants wanted to worship God in their own way, and many of the colonies established particular religious sects. For example, Massachusetts was a haven for the Puritans, Rhode Island a haven for the Baptists, Pennsylvania for the Quakers, and Maryland for Catholics. In most colonies, the Church of England was the established church. It may surprise you to know that all of the churches in the original 13 colonies were state-supported. The first state to remove state support from churches was Pennsylvania in 1790, and the last was New Hampshire in 1877. Massachusetts disestablished the state church in 1833. We all remember from grammar school, at least those who are around my age, I don't know what they're teaching young people today. We remember the original 13 colonies were essentially an extension of Great Britain, the greatest world power at that time. Beginning in the mid-1700s, King George III established a series of governmental policies that created excessive taxation on the American colonies, particularly the Stamp Act of 1765 and the Tea Act of 1773, which placed high taxes on tea exported by the British East India Company. As you all know from your history books, this in turn prompted the Boston Tea Party right here in Massachusetts, in which patriots destroyed an entire shipment of East India tea by casting it into the Boston Harbor. As we all know, that prompted the slogan, "No taxation without representation," which finally led to the American Revolutionary War. As we know, the United States came into existence on July 4th, 1776, through the Declaration of Independence. The Declaration is our country's founding document and laid down the principles on which the new nation was to be formed. First, The Declaration explicitly cited the laws of nature and nature's God as the legal authority, allowing the colonies to separate from England. It specifically acknowledged that certain truths were self-evident, meaning not subject to debate. Among those truths was the first principles that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among those rights are life, liberty, and the pursuit of happiness, that governments are instituted among men to secure those rights, and that when any government becomes destructive to those ends, it is the right of the people to alter or abolish it. The Declaration concludes with an appeal to the Supreme Judge of the world and a firm reliance on divine providence. The signers pledge their lives, their fortunes, and their sacred honor to each other in support of the Declaration. During the Revolutionary War, the United States was governed by several versions of what was called the Articles of Confederation. The Articles were unsuccessful, and in 1787, a constitutional convention was called that took place in Philadelphia over a period of 4 months. At one point during the convention, at an impasse, the elder statesman Benjamin Franklin reminded the participants of who the true architect of governing law really is. This is what he said. In this situation of this assembly, groping as it were in the dark to find political truth, scarce able to distinguish it when presented to us, how has it happened that we have not once thought of humbly applying to the Father of lights to illuminate our understanding? In the beginning of the contest with Great Britain, when we were sensible of danger and had daily prayer in this room for divine protection, our prayers were heard and they were graciously answered. All of us who engaged in the struggle must have observed frequent instances of a superintending providence in our favor. And have we now forgotten that powerful friend? I have lived a long time, and the longer I live, the more convincing proofs I see of this truth, that God governs in the affairs of men. We have been assured in the sacred writings that except the Lord build the house, they labor in vain that build it. I firmly believe this, and I also believe that without his concurring aid, we shall succeed in this political building no better than the builders of Babel. The result of the convention was the United States Constitution, the first written constitution in world history. As we know, it created a federalism form of government, meaning that two forms of government, state and federal, govern the same territory. The states had the general authority to govern within its borders, and the federal government was given very limited powers. As we know, the federal government has three independent branches: the legislative, the executive, and the judicial. The Constitution itself gives most attention to the legislative branch and a considerable amount to the executive. Very little attention is given to the judicial branch in the Constitution. And here's why. During the ratification debates, Alexander Hamilton said the judicial branch was the least dangerous and weakest of the three branches because, quote, it has no influence over either the sword or the purse. It may be truly said to have neither force nor will, but merely judgment. The Constitution was ratified by the states in 1788 and went into effect in 1789. In 1791, certain amendments to the Constitution were ratified. They are known as the Bill of Rights and contain the first 10 amendments. The very first amendment, the one that was most important to James Madison, who authored the Bill of Rights, says, in the very first instance, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right to the people to peaceably assemble and to petition the government for redress of grievances. Notice that the amendment was limited to Congress. Congress shall make no law. It was limited to the federal government and had no application to the states. At the time, and even still up to today, each state has its own constitution that offers similar protections. Our federal constitution has stood the test of time. It's 226 years old. In 1803, during his presidency, Thomas Jefferson said, "Our peculiar security is the possession of a written constitution. Let us not make it a blank paper by construction." 1 year later, in 1804, in the seminal case of Marbury versus Madison, Chief Justice John Marshall firmly established the principle of judicial review, holding that the courts have the authority and power to review acts of Congress and declare them unconstitutional. Up until the late 1800s, students studied law by actually studying the laws that were already established. Not complicated, right? In essence, they were told what the law was by their instructors. One of the most widely used textbooks back at that time was William Blackstone's Commentaries on the Laws of England. In the mid-1700s, Blackstone had assimilated all of the common laws of England. Common law is derived from custom or judicial precedent. Importantly, cases decided by judges were not law in themselves. The judge's opinions were merely evidence of what the law was. It was not the role of the judge to make subjective judgments, but rather merely to declare what the law was as it existed at the time. There was no such thing as judge-made law in the 18th or 19th centuries. But the study of law changed in the late 1800s when a law professor named Christopher Columbus Langdell introduced the case method of study at Harvard University. The case method studies law pragmatically. It studies the opinion of judges rather than, as before, being instructed in what the law actually is. It requires students to use their own reason to understand how a particular law might apply in a given case. Some of you may remember the movie The Paper Chase, in which Professor Charles Kingfield instructed through the use of questioning, and some would say torturing, his students. In actuality, the case method of study elevated the reasoning and the opinion of the judges over the rules of law that had existed for centuries. Eventually, cases were no longer evidence of law, but became law in and of themselves. 40 years after Langdell introduced the case method at Harvard, then Chief Justice of the United States, Charles Evans Hughes, also a Harvard graduate, said this: "We are under a written constitution, but the Constitution is what the judges say it is." Judges have their own personal biases. Some have their own political agendas. In any event, in many instances, it's impossible for a judge to separate his political leanings from objectivity when it comes to judging a case. Ever since, the United States has been ruled by an oligarchy of 9 men and women called the Supreme Court. In 1943, in the case of Board of Education v. Barnett, the Supreme Court issued one of its pinnacle decisions protecting religious and natural freedom. That opinion says in part, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. Only 4 years later, that decision began to erode. In 1948, in the case of McCollum v. Board of Education, the Supreme Court ruled that religious instruction in public schools was unconstitutional. It held that, quote, in the words of Jefferson, the clause against establishment of religion by law was intended to erect a wall of separation between church and state. But that case took Jefferson's statement and turned it on its head. In a letter written in 1802 to the Danbury Baptist Association, Jefferson had said this: believing with you that religion is a matter which lies solely between man and his God, that he owes account to none other for his faith or his worship, that the legitimate powers of government reach actions only and not opinions, I contemplate with sovereign reverence that the religion clauses of the First Amendment build a wall of separation between church and state. In essence, what Jefferson was saying is that the Establishment Clause was designed to protect the people from the government, from overreaching in matters of religion. Nothing in that letter hints that Jefferson saw the Establishment Clause as forbidding religion's influence on government. Over the next several decades, religious freedom began to erode. In 1962, in the case of Engel v. Vitale, the Supreme Court ruled that public school composed prayers are unconstitutional. 1 year later, in 1963, the High Court ruled that public school-sponsored Bible reading is unconstitutional. In 1987, the Supreme Court ruled that the teaching of creation, as set forth in the Holy Scriptures, could not be taught in public schools. Going back 7 years, in 1980, in the case of Stone v. Graham, the Supreme Court made one of its most foolish pronouncements ever. It said that the posting of the Ten Commandments on public school walls was unconstitutional. Its reasoning? Quote, posting of religious texts on the wall serves no educational function. If the posted copies of the Ten Commandments are to have any effect at all, it will be to induce the school children to read, meditate upon, perhaps venerate, and obey the commandments. Think about that for a moment. Essentially, the court said that there is no educational value in teaching children that certain laws proceed from their creator. What a far cry from the Declaration of Independence, which solemnly proclaimed that our Creator endows us with certain unalienable rights. By the way, some of you here may know this, but the very first law requiring public education in America was passed right here in Massachusetts in 1647. It was called the Old Deluder Satan Act. Its purpose, to teach children to read. Why? Because that old deluder Satan tried to keep men from the knowledge of the Scriptures. How about that? Today, public schools teach moral relativism, and situational ethics. They teach that there is no objective standard of truth, and everything is open to debate. Just ask Brian Kemaker about that. They say, think as you will, do as you feel. That is, so long as the way you think aligns with the government. Now, during that same period, when the Supreme Court was cleansing religion from the public schools, it was issuing decisions dismantling legislatively imposed morality. This dismantling can be traced to 1965 in the case of Griswold v. Connecticut. In that case, a Connecticut statute had prohibited the use of artificial contraception. Though the law was rarely enforced, the Supreme Court declared that it violated the constitutional right to privacy. Of course, nothing in the Constitution speaks of a general right to privacy. And prior to Griswold, the Supreme Court had never used that term. So, where did it come from? The Supreme Court tells us. In Griswold, the Supreme Court said that the right to privacy emanates from the penumbras of the Bill of Rights. Did you get that? The right to privacy emanates from the penumbras of the Bill of Rights. A penumbra is a shadow. For instance, when we see less than a full moon in the sky, the remainder of the moon is hidden in the penumbra, the shadow. Of course, we can see the full moon at certain times during the month. But unlike the full moon, the contours of the right to privacy cannot be known because they're hidden. Only Supreme Court justices can see them or find them. This, of course, means that anything can be a constitutional right if the justices say so. The right to abortion is hidden in the penumbras of the Constitution, in the Bill of Rights. The right to homosexual sodomy is hidden in the penumbras of the Bill of Rights. In a few months, we are likely to see the Supreme Court find the right to same-sex marriage hidden in the penumbras of the Bill of Rights. Thomas Jefferson's fear has become real. The Supreme Court has made the Constitution a blank piece of paper by construction. Of course, competing rights are now on a collision course. Long recognized rights of conscience, so well articulated in the Barnett case, are giving way to newly recognized rights that clash with sincerely held religious beliefs. Thus, as Mark Rienzi can tell you, the Obama administration says that the Catholic Sisters of the Poor must provide contraception to its employees. Imagine forcing Catholic nuns to provide contraception in violation of church teaching. The state of Oregon fined a Christian baker for refusing to make a cake for a same-sex wedding because it violated the baker's sincerely held religious beliefs. A judge in Washington state held that a Christian florist violated anti-discrimination laws when she refused to provide flowers for a same-sex wedding. Why? Because she felt it violated her sincerely held religious beliefs. Both New York and New Jersey have fined Christians for refusing to allow same-sex marriages in their banquet facilities. Folks, religious persecution in America is here. We won't see beheadings, but we will see increased fines and perhaps even jail time for people who refuse to violate their consciences. Folks, the America we've all have known and love is gone, and it's not coming back in our lifetimes. Like the ancient nation of Israel, as described in the book of Judges, we have forgotten God. Today, many men and women have a form of godliness, but they deny its power. St. Paul, in a letter to Timothy, describes these people as always learning, but never able to discern the truth. In large part, it is people like this who are in control of our government. Now, you may be asking yourself, how did we get from the morally consistent 1950s, when American life was exemplified by Father Knows Best, Leave It to Beaver, and the Donna Reed Show, when America's slogan was baseball, apple pie, and Chevrolet, when students got in trouble for nothing more than chewing gum, throwing paper airplanes, or whispering in class? How is it that from the 60s and beyond, almost all wholesome moral constraint has been cast off? Some people may think it was an unfortunate coincidence. Others believe it was a carefully orchestrated, sinister scheme. Dr. Judith Reisman, who has made a career of studying the negative effects of pornography, believes it all started in the 1940s. According to Reisman, it began with Alfred Kinsey and the elites. In the 40s, Kinsey purported to conduct several studies that he parlayed into 2 books known collectively as the Kinsey Report. The Kinsey Report purported to address, or expose, if you will, the sexual mores of Americans. The books created outrage because they challenged the American norms of sexual behavior. According to Kinsey, what Americans did behind closed doors was a far cry from what they claimed was acceptable sexual behavior. But according to Reisman, what Kinsey failed to disclose was that people who were interviewed for his so-called study were prison inmates, homosexuals, pedophiles, and prostitutes. That's where he got all of his statistics, or certainly a great many of them. According to Reisman, Kinsey was a sexually promiscuous bisexual. In the mid-1950s, it appears that Kinsey worked with the American Law Institute to revise what was called the Model Penal Code. The revised Model Code deleted many crimes that were based on sexual behavior. Over time, the Model Code's influence on sex crimes made its way into state criminal codes. So was the dismantling of sexual crimes and the loosening of morality a mere coincidence? You decide. So, what do we do? First, we must, as did our forefathers, mutually pledge our lives, our fortunes, and our sacred honor to each other. Second, we must stand up and out against the overreaching government, both state and federal. Third, we must think generationally. It took 50 years to get us to this point, and we should not believe that we can reverse it in 1 year, 5 years, or even 10 years. We must have a long-term strategy. Fourth, we must counteract the public schools, the media, and political activists by teaching our children and grandchildren what is true, what is right, and what is good. The Bible is a lamp unto our feet, a light to our path. It is the truth that shall set us free. Fifth, we must be willing to suffer. Finally, we must rely on our faithful friend, our God. Like Ben Franklin, we must say, unless the Lord builds the house, he who builds it in vain. That's the bad news. The good news is that we prevailed 9-0 in the United States Supreme Court last year in the case of McCullen v. Coakley. We are making inroads, but we are not overcoming the deeply ingrained problems that we have suffered over the past 50 years. My friends, I hope you, as I do, are willing to stand up and be counted and lose everything that we have for the sake of our children, our grandchildren, our nieces, and our nephews. God bless you, and God bless the United States.